and thank you for joining us. My name is Katie Perez, and I'm a Senior Associate here at Scott Legal PC. Today, we're going to spend some time talking about the L-1 and EB-1C visa requirements, but just a few things before we get started. Some of you may know that the firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the U.S. on an E-2 visa and has been on several different visas, including an F-1, TN, B, and an H-1B. Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including E2, E1, TN, L1, family immigration, national interest waivers, EB-5, extraordinary ability visas, and more. So we will continue this webinar series doing at least 2 webinars a week on different topics. At the end of this webinar, we will send out several useful tools. We will send you a copy of the PowerPoint presentation from today, a link where you can download guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. So this webinar will be recorded and available on YouTube. We will also send you the link for that. We encourage you to subscribe and hit the notification button, as we do regularly upload immigration videos on a wide variety of topics. We'll also send you a link where you can arrange a consultation with one of our experienced attorneys if you would like to discuss your case in more detail. If you do have any questions throughout this presentation, please put them in the chat box and we will address them at the end of the presentation. So today I will present the first half of the webinar. My background does include 10 years of experience with USCIS, where I did adjudicate the L petitions. We are also here with our partner, Kelly Weiner. She is a partner at Scott Legal PC and has an extensive experience processing the employment-based visas to include the L1 and the EB-1Cs. So now we will get started. So what is the L-1 visa? The L-1 visa is a non-immigrant temporary work visa that allows a company to transfer certain qualified employees serving in a managerial, executive, or a specialized knowledge role from one of its foreign offices to a related office here in the U.S. So there must be a qualifying relationship between the foreign and U.S. companies. The qualifying relationship can be that of a parent, subsidiary, affiliate, or branch. The non-immigrant classifications for this section of law are the L1A and the L1B. The L1 visa can be an option for companies that have been doing business in the United States for an extended period of time, which at least 1 year or more, and that company wants to send an individual who's qualified to the U.S. However, the L visa can be an option for companies that have never done business here in the U.S. but are looking to grow their business and expand here. So companies that have not been doing business in the U.S. would file for what we call a new office. And then a new office is defined as an organization that has been doing business here in the U.S. operating for less than 1 year through that qualifying organization. So both the L1A and the L1B petitions can be filed as new offices. So we will now also discuss a little bit more the specific requirements for the L1 visa. So again, when an employer wishes to transfer an employee of the foreign company to the U.S. company here as the L1 non-immigrant, they must demonstrate in part that the companies have a qualifying relationship. Again, the types of qualifying relationships can include the parent, affiliate, branches, or subsidiaries. But here it is really important to look at how the companies are related, because there are specific definitions in the immigration regulations for each type of relationship. So before you file your petition, it would be really important to look at the documents such as operating agreements or other formation documents to really determine the ownership and control of each organization. Although you may think that the companies do have this qualifying relationship, because there are specific definitions, you do really need to consider the ownership control of each organization. So for example, you may think your foreign and U.S. companies are affiliates because they share some type of a shared ownership between the companies. The same person owns maybe part one of one company and part of another company. As an example, if you have company X and they are owned by A, B, and C, and each of those people own equal shares, and then you have company Z and it's owned by A, B, and D, also each owning equal shares. Although a large portion of both companies are owned by the same people, This would actually not meet the definition of an affiliate based on these very basic facts because it's not owned by the exact same group of people. So again, it is important to do the analysis of the ownership and control of the companies to ensure the foreign and U.S. companies have a qualifying relationship that satisfies one of the definitions before you file your petition. You must also show that the foreign and U.S. companies are both doing business on an ongoing basis. Doing business is defined as the regular, systematic, and continuous provision of goods and or services. So therefore, you would need to provide proof that both companies are actively doing business, actively trading. Typical evidence for this requirement would include taxes, maybe showing that you have had sales or income. You could also provide invoices, things like that. There is no statutory or regulatory minimum level of business activity that must be conducted in order to meet this eligibility requirement. Determining whether a company is doing business would be on a case-by-case basis. So here the government would likely look at things like what type of business do you have? What are the needs of the organization? So if you own a business and you're selling goods, but and say, for example, you provide the government with invoices from January 2025 and August 2025, but you have very low revenues, maybe you do not have very many employees, the government would likely question whether you really are doing the regular systematic continuous provision of goods and or services. And it would be your burden to show that you're doing the regular business. The doing business requirement does impact the type of petition you will file. We touched upon this in the other slide, but if a company is a startup company, you haven't been doing business here for more than a year, you could file for the L-1 new office. With the new office, excuse me, visa, the U.S. company would have a year to get the business up and running to show that you are doing business. So you don't need to show regular business at the time of filing under the new office. Another consideration for doing business and the type of petition you might file is you could possibly have an organization here in the U.S. and they may have had a legal existence for a year, a couple years, but you weren't actually doing business. So this business could also be defined as a new office. So more specifically, an example, say you had a company incorporated 2 years ago, but it's just been this passive entity. There were no sales or services being conducted, no taxes to show the revenue, then you could qualify this as a new office. So doing business does not include the mere presence of an agent or office. You do have to show activity. Another requirement is that the employee has at least one continuous year of full-time employment abroad with a qualifying organization within the 3 years preceding the filing of the petition. The employee's prior year of employment abroad must have been in the position that was managerial, executive, or did involve the specialized knowledge. There are very specific definitions for each of these positions. So specific definitions as to who would qualify as a manager, executive, or the specialized knowledge, and we will discuss that in a later slide. For the L-1A petition, which is the manager or executive position, you can be approved for initial grant of 3 years, and then you can renew in increments of up to 2 years for a total of 7 years. The L-1B, you can also be approved for an initial period of 3 years and then renewed in increments of 2 years as well for a total of 5 years. Under the L petition, you can recapture time. So for example, if you spend a few weeks out of the U.S. each year, you could reclaim that time. So you can remain in the U.S. under the L petition for a total of 7 years, and time spent outside the U.S. would not count against that clock. So it is helpful to keep track of your trips, although the government does have access to most of your travel records. Sometimes they're not complete, and it would be your burden to let them see that you are eligible to recapture the time. Okay, so as we mentioned before, there is something called a new office for the L-1 visa. The new office is an organization that's been doing business in the United States through a parent, branch, affiliate, or subsidiary for less than 1 year. So if the company is sending an employee to open the new office, there are some additional requirements, and we will discuss those. So the new office requirements. One requirement specifically for the L1A new office um, would be that you need to show that you have secured sufficient physical premises to house this new office, this new business. The physical premise really needs to make sense with the type of business you plan on conducting. So let's say you plan on doing an import and export business and you need a warehouse to house your goods. Perhaps you've indicated to the government in your business plan that you are going to hire 7 employees in the first year. So if you're filing your petition and you give the government a lease that's for 100 square feet, there's one desk, no warehouse. The government might say you haven't satisfied this requirement because here you've indicated you need a warehouse, but you haven't explained how you will do business without this warehouse. So the government really wants to see that what you've laid out in your business plan matches up with the evidence you're providing them. So if you need to consider the type of premise you would need for your specific business. Also regarding this physical premise requirement, it has become a little bit more malleable in recent years with after the pandemic. However, the government doesn't typically like to see like the co-working spaces, and you may receive pushback on this type of lease. But however, if you can demonstrate that the lease or the physical premise you have secured makes sense in the type in light of the type of business you plan on conducting, this requirement shouldn't be too big of a hurdle, and usually the government doesn't focus too much on it. Really, you just need to show at the time of filing you have what you need and what makes sense in what you've indicated in the business plan. If you are coming to the U.S. under the L1A new office to fill the manager or executive role, your qualifying experience abroad must have also been in a managerial or executive capacity. So unlike other L1 petitions, eligibility for the L1 new office approval may not be established through qualifying experience involving the specialized knowledge. Okay. So with the L1A new office, you do need to show, you do not need to show that you have employees before you apply for the visa. But you do need to show that the petition will support a manager or executive position within 1 year. In order to determine if the U.S. operation will support the manager or executive position within 1 year, the government will want to see the scope of the office, the organizational structure, the financial goals of the company, your hiring plan, and how you will accomplish these goals. They will want to see the size of the U.S. investment and the financial ability of the foreign company to pay the employee and start the business here in the U.S. They will want to know if the foreign company is going to capitalize the U.S. company, how you are going to get this business up and running. Sometimes with the new office, you will see the government say that the foreign company needs to capitalize the total expenses at the time of filing. However, you can push back on this because it's not specifically in the regulations, but it is important to show that the foreign company is solvent, that they have some funds to support the U.S. company. I have seen cases where the foreign company had negative balances in their bank accounts or little to no funds, so this would be a red flag. So while you don't need necessarily all the funds at the beginning when you're filing, you should be able to show that the foreign company can at least support the U.S. company and pay the U.S. employee. So another consideration you would want to think about, will the foreign company, foreign organization support the U.S. organization with personnel and in what capacity? For example, maybe you don't have plans to hire administrative support initially, but the foreign company will provide this. So you could explain that in your petition. It helps give context to the petition, what you're going to do with the business, and give the government the ability to kind of understand why this new office would be successful. It is understood that the manager or executive who is coming to open the new office may be more actively involved in the day-to-day operations during the initial phases of the business, but the manager or executive, they need to have the authority, the intent to hire staff. So you can intend to be the personnel initially doing these operational duties of the business, but you do need to show by the end of the first year that you would have personnel this, to relieve you of those operational duties so that you can primarily perform the executive or managerial duties. Okay, so as we mentioned before, you can have an L-1B new office as well. The L-1B new office would be for someone who has served abroad in a specialized knowledge role for at least 1 year and is coming to serve in a specialized knowledge role here in the U.S. Um, so you do need to show that the employee does possess specialized knowledge and that the foreign and U.S. positions will involve specialized knowledge. You still do need to show that you have secured that sufficient physical premise to house a new office and show that the petitioner has the financial ability to remunerate the employee and commence doing the business here in the U.S. Okay, so again, the L1 does have specific definitions for the executive manager or specialized knowledge employees, and each of these do have specific definitions. So here we have first the executive capacity. Executive capacity means an assignment within the organization in which the employee primarily directs the management of an organization or a major component or function of the organization, establishes the goals and policies of the organization, component, or function, exercises wide latitude in discretionary decision making, and receives only general supervision or direction from higher level executives, the board of directors, stockholders of the organization. So, really, to demonstrate executive capacity, you need to show the beneficiary will perform certain high level responsibilities. You need to show that the beneficiary will primarily engage in those executive duties as opposed to the operational activities alongside the petitioner's other employees in the organization. It would be really important to detail the beneficiary's duties, explaining what the beneficiary will do on a daily basis, and that their duties are primarily, again, executive in capacity. So if you're choosing to classify your employee as an executive, it is really important to describe the role in a manner that lines up with the definition and support that description with evidence. For example, the definition states the executive needs to direct the management of an organization. The executive can direct the management of an organization by controlling the work of other managerial employees or lower level executives. The control can be direct supervision or sometimes more indirect. But if you claim you're an executive, you would need to show that there is a management, um, i.e., that there are employees serving in managerial positions. So most commonly, when you have an executive claim, you would have an organization that's probably multi-tiered. I mean, it's not a requirement, but that would be able to show that you have maybe a lower level of managers who are overseeing other employees. In order to help demonstrate that you are an executive, you would just really want to detail your duties and provide that percentage of time to really show in the adjudicator that your duties are primarily executive. You'd also want to detail the structure of the organization and provide the duties of their subordinates. This will also help as well to show who's performing those operational duties so that you as the executive can show that you're relieved from performing those duties. An executive title alone won't be sufficient to show the adjudicator that you are serving in an executive role. You just really do need to think about the structure of the company overall, how many employees are there. It just won't be about the title only. It will be about the substance of the job, the position. So really, what are you or the beneficiary going to do on a daily basis? And if the structure really doesn't support that this person could serve as an executive because the company is very small, there's not a lot of employees, you may want to consider a different category like the manager role or maybe a specialized knowledge employee role as opposed to the executive role. Okay, so now we will discuss managerial capacity and we will switch to Kelly, who will go over that definition for us.
Thank you, Katie. All right. So, kind of similar to executive capacity, managerial capacity has kind of a very, specific definition. And a job title alone will not be sufficient to prove that somebody is a manager. There's a lot of job titles that include, the word manager in it. So you really have to kind of go beyond that to make sure that they qualify using the regulatory definition. So you can see here, managerial capacity means that you manage an organization, department, subdivision, function, or component of the organization. There's kind of two ways to be a manager. One is a personnel manager. So you're a manager of people. So you supervise and control the work of other supervisors, other managers, or professionals, meaning jobs that require bachelor's degrees or higher. Um, or you manage an essential function of the organization. And so, function manager is a category that can be used for somebody who meets the criteria for manager, but does not really have direct reports. Perhaps they have lots of indirect reports that are doing, actually doing the operational work, and then they kind of manage and oversee that function. So you going down the list, you have to show, authority to hire and fire, recommend personnel actions, and exercise discretion over day-to-day operations of the activity or function. They do note that a first line supervisor is not considered to be a manager. So you do have to really look at what, if someone is a personnel manager, you have to look at who are they managing? Are they themselves managers or professionals? If they're not, and if it's just kind of skilled labor petitions, it's going to be very difficult to get a, kind of manager approved for, that type of role. Okay, we can go to specialized knowledge. So the L-1B, so what is specialized knowledge? This means special knowledge possessed by the individual of the organization's products, services, research, equipment, techniques, management, or other interest and its application in international markets. Or it could be an advanced level of knowledge or expertise in the organization's processes and procedures. So sometimes people feel, well, if you don't qualify as an executive or a manager, you could just, qualify under the L-1B. And that's really not the case. It is quite, difficult to qualify under the L-1B in the sense that you really do have to show, why this person is needed in the U.S., that they do have this specialized knowledge. And it often involves a comparison of kind of others within the industry generally, like what knowledge do they have that couldn't be found kind of in the U.S. labor market or specialized knowledge of the particular organization. So for example, if you have somebody who perhaps when you look at the industry generally might not be considered to have knowledge that's that specialized, but perhaps they were really like, foundational in this particular company. Maybe they designed the processes and procedures. They know how certain things work, and that's extremely valuable to the company, and to its marketability and its economic success. That can be something that you can potentially use if it's perhaps, that type of situation where maybe you have an employee earlier in their career, but who has been extremely important to, the success and setup of this particular company. That can be one strategy to use. All right, so let's turn to what documents need to be submitted for an L-1. So you have to submit a form with U.S. Citizenship and Immigration Services. This is called the I-129. Along with this, you're going to submit corporate documents showing that there's a qualifying corporate relationship between the companies. So, parent, branch, subsidiary, affiliate, proof that each company is doing business, or if it's a new office, that the new office is, will be ready to do business. Proof that the employee worked for the company abroad for one continuous year out of the past 3 years in a managerial, executive, or specialized knowledge role. You're going to include things like pay stubs, personnel records, very detailed job descriptions that give examples. Often good to support that with objective work product so that they feel that you're really backing up the statements that you're making about what the person's job is. Also good to include organizational charts showing the employee hierarchy. Information about the people that are being managed or who are in the hierarchy can help as well. You also have to include proof that the role in the US will qualify as a managerial, executive, or specialized knowledge role, and you're going to include similar documentation, although you may not have work product yet. because they haven't been working in that role. Important to note that the role abroad and the role in the United States do not have to be exactly the same. Somebody could be, for example, a manager abroad and be transferred to be an executive in the United States, or could have been a specialized knowledge worker abroad, transferred to be a manager in the United States. However, if the roles are going to be different, you also need to include the proof that the person is qualified for the role they're being transferred to in the United States. So their resume, their degrees, any work product or explanation of how the jobs that they've held in the past or, with the company have prepared them for the job they're going to hold in the United States. Okay, so what do you need for a request for evidence? So requests for evidence are relatively common for L-1 petitions, although the rates have dropped over the past few years in a significant way. There was a period of time where RFE rates were over 50%. So extremely high, whereas recent data shows that RFE rates are more in the 30s as opposed to the 50s in terms of percentages. There has been a significant drop. That being said, there's still a fair number of RFEs. Most of them, even if they have kind of other issues they bring up, most of them also challenge, the definition of manager, executive, or specialized knowledge worker because they are so specific. Um, and perhaps, it can be very common sometimes to submit more generic, job descriptions that may not really address, the specifics. It's very common to get an RFE on this particular issue. It's helpful to include detailed support letters and organizational charts, but this really, if you get an RFE especially, needs to be supplemented with objective evidence to support the statements that you're making in the letters and the org charts. You want to include things like work product with kind of explanations of what the work product is showing. So it's not really helpful, for example, to submit, here's a bunch of emails or here's a bunch of work product. You need to explain to the officer how that, correlates to show that the person qualifies as an executive manager or specialized knowledge worker. But emails, things like that can be very helpful if they show, hey, this person is, always having meetings with senior level people within the company. They've drafted the policy handbook. Here's the performance reviews that they do for their staff. All of these things are very helpful to prove that people kind of meet the actual, regulatory criteria. All right, let's talk about kind of timing for L1 petitions and dependents. So the way that it works for most L1 petitions is that first it must be approved by U.S. Citizenship and Immigration Services. Regular processing times are several months, but there is an option to pay an additional fee to get a response within 15 business days. That can be an approval, denial, request for evidence, notice of intent to deny. If it's a request for evidence or notice of intent to deny, you can send your response, and then if you've paid the premium processing fee, they'll issue usually a final decision within the 15 business days. Every now and then you get a second RFE. It's very uncommon, but is, hypothetically possible. After you get the approval, the employee applicant will schedule an appointment at the U.S. consulate in their country of residence or nationality to get their L-1 visa stamp. Let's say that the employee is already in the U.S. Maybe they entered as a B-1 to investigate or get an office for their new office. In that case, they can change status to L-1 if they don't want to depart immediately. So that's something that is possible as well. Spouses and unmarried children under 21 can accompany on L2 dependent visas. The spouse does have the ability to work. They can work anywhere on the L2 spousal status, and the children can attend school, although they cannot work. A couple caveats here, in terms of timing and process. One is that if you are Canadian, then you are visa exempt. And so for your initial L1 petition, you can, instead of going through USCIS, you can actually go to the border and they will adjudicate it, kind of at the border. There also might be a slightly different process for companies that, what we call blanket petitions, where these are companies that are very large, multinational companies that have submitted additional documentation and have a more streamlined process for some of their L applicants who can apply directly at the consulate. But for the vast majority of, L applicants, this is the process that they will follow. All right. So does an L1 lead to a green card? So very common question. And Well, there is no non-immigrant visa that kind of automatically turns into a green card. So that's, I think, a common misconception sometimes that if you spend a certain amount of time on a temporary visa, that there will automatically be some ability to transition to a green card, and that's not the case. That being said, there are green card if you're in the U.S. on a temporary visa, and there is a green card category that's available to you. You can apply for that. And for the L1, a common category that can be used for executives or managers would be the EB-1C. So this has a very similar set of requirements to the L1A, but there's a heightened standard because instead of a temporary visa, this is a permanent, green card. There's also the requirement that both businesses, including the US business, have to have been doing business for at least 1 year. So there's not kind of this new office option that you have with the L, that's not available with the EB1C. Um, it's also important that the employee in this case only qualifies if they worked as a manager or executive abroad. So for the L, you could be a specialized knowledge worker abroad and be transferred as an L1A to be an executive or manager if your role in the United States is executive or managerial. However, in that case, you would not be eligible for the EB1C because your role abroad was not that of an executive or manager, and that's what's required for the EB1C. A benefit of the EB1C is that you can skip kind of the normal employer sponsorship labor market test, so it's much faster. You can pay a fee to have the government, issue a decision within a short period of time. And then the EB1C category is often current, meaning there's often green cards available, kind of more quickly than for some other categories, which are a bit more backlogged. So it's a very attractive category for many reasons, if you are eligible for it, and is a great option for people on the L1. That being said, let's say that your company abroad was very small and you had a very, very difficult approval for your L1A. Once you go for your EB1C, you're going to have to face those same difficulties because they will look back at, even if you've been in the US for 3, 4, or 5 years on the L1A, they will look back at what was your role abroad. And so if that was very difficult to convince USCIS initially that you qualified for the L1A, you will face those same issues again, in your EB1C filing. Um, the other option would be the perm process. So people who are, specialized knowledge workers, or, so an L1B status, or maybe held a specialized knowledge role abroad, they can go through what's called the perm process. This is where the U.S. company will sponsor them for a green card, usually in category EB2 or EB3. The company will have to test the U.S. labor market. So they file for a prevailing wage determination, do an actual labor market test where they place ads to see if there's any willing, qualified, and available U.S. workers. If there's not, then they'll file the labor certification. That whole process is taking quite a long time, even up to and over 2 years. Once you get that approved, then you would go ahead and file an I-140 petition showing that the applicant has all the criteria for the job and also that the company can pay the prevailing wage, and then you would file your green card application. So it's a much longer process than the EB1C. There are potentially other options. For example, the national interest waiver, if someone's an L1B and has a lot of extremely specialized knowledge and works in an area of substantial merit and national importance to the US, that could be another option. We do have a separate, webinar that goes over kind of, green card categories generally. But these two that are listed here are the ones that are most often used by the L1, visa holders to transition to green cards. All right. So I don't think any questions have come in. Um, so we will close here. Thank you everyone for joining. Thank you, Katie, for joining and
Thank
sharing
you.
your knowledge. Hope you have a wonderful day.
You too. Bye.